Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal.
And I'm Mary Margaret Bush, Napa Legal's Executive Director. You're listening to the Napa Legal Weekly Podcast, where we explore religious liberty from the perspective of faith based nonprofits. This week, we'll be exploring a religious liberty lawsuit at Liberty University related to some employment matters. We'll be looking at a case against the U.S. Conference of Catholic Bishops related to the Peters Pence collection, and a study showing the results of Mackenzie Scott's large philanthropy and its impact over recent years.
Great. Well, in the interest of time and some really heavy cases here, let's dive in. So we will start with religious liberty at Liberty. This is a really interesting case, and I was just saying to Mary Margaret before we got on here that there's more here than we could cover, even if we just focused on this one case for an entire episode. So unfortunately, we're going to have to skip through some pieces of this case and focus in on a couple that I think are most relevant to our listeners. So really quickly, the facts of this case: Liberty University, which most of you listening are probably familiar with, it's a major Christian university in Virginia. Um, they have, like a lot of religious institutions, they have a publicly posted doctrinal statement that explains the particular religious beliefs of the organization. Included in that doctrinal statement at Liberty is that people are created by God as male and female from conception. So, as part of its employment policy, Liberty provides this statement of faith to its employees during the onboarding process, and it does require that they acknowledge the policy. So, the conflict in this case happened when an employee named Jonathan Zinski, who was newly hired, was terminated after he informed the supervisors at Liberty that he intended to transition from male to female. So he wrote a letter to Liberty. It's actually very interesting because obviously you don't want to guess at motives, but it's a really interesting letter because the way that Mr. Zinski, well, well, the way that he characterizes the situation, he makes it a really interesting legal question. So in this letter, the um, the employee, sorry, I'm struggling with the pronouns because it's a biological male who now identifies as female, so I'm just gonna say Zinski. um, Wrote a letter to Liberty, and what was said there was that, I remain a Christian. I go to a church. I'm a faithful lover of Christ. I'm happy to be at Liberty University, and I hope that my employment relationship here can continue as I. And then Zinski goes on to explain that he's taking cross-sex hormones and has been doing so for months before he even started working at Liberty. So it's interesting, and we'll get back to this, but Title VII of the Civil Rights Act allows religious organizations like Liberty to be exempt from religious discrimination cases, right? They're allowed to discriminate on the basis of religion, but not of sex, arguably. So this is where the whole fight happens. And this has happened on a lot of civil rights cases. It gets very difficult to kind of find the lines between religious and sex-based discrimination. And so what Zinski did in this letter was make it very clear that I consider myself a practicing Christian, a lover of Christ, which I think was trying to take the religion issue out of the firing process, so that if and when Liberty did terminate Zinski, they would say, well, it's based on our religious beliefs, and Zinski would say, well, no, it's not. I'm still a Christian. You're a Christian university. What's the problem? This is the back and forth in most of these Title VII cases. We'll get back to that in a couple of minutes. So Liberty responded to Zinski's letter, said that the actions of taking cross-sex hormones and transitioning away from biological sex to a different gender identity are not consistent with Liberty's Christian identity. That's how the lawsuit originated. It's a long lawsuit. There was recently a motion to dismiss by Liberty on Title VII grounds and several other grounds. The district court judge denied the motion to dismiss, so the case is ongoing. Liberty's going to appeal it to the Fourth Circuit. I think we have good reason to believe that this may go up high. This could even be a potential case for the U.S. Supreme Court to weigh in on. And so there's a lot going on here. There are First Amendment arguments. There are federal Religious Freedom Restoration Act, RFRA arguments. And of course, there's a lot of talk about Title VII in the Civil Rights Act and how those exemptions come into play. So again, the opinion denying Liberty's motion to dismiss is about 70 pages long. So two things to note there. First, obviously, I'm going to have to skim over a lot of it. There's more than we can cover here. But I would also say that I think it's interesting to know that this opinion is really long, very dense, It's comprehensive. Every issue that was raised by Liberty is treated in some depth. And I have to say, it does a fairly impressive job, even though I disagree with how it came down. But it covers both sides of each argument, especially the Title VII argument, in a lot of detail. So if I had to guess, I think the judge probably was fairly confident that this case would go up on appeal and was giving quite a detailed opinion to send up to the appellate court. So again, as much as I disagree with the decision, it was impressive, the scope and the depth of this opinion. Um, Two things that I think deserve quick honorable mention before we jump into the Title VII issue and the scope of the Title VII exemption for religious organizations. So one, I think it's interesting that in the court's opinion on RFRA, right, there was a challenge that this violated the religious exercise rights of liberty under the Religious Freedom Restoration Act, and the judge made what is an interesting point that you know the RFRA statute at the federal level on its face says, I'll quote it here: a person whose religious exercise has been burdened in violation of this section may assert that violation as a claim or defense in a judicial proceeding and obtain appropriate relief against a government. So the judge points out this opinion doesn't have a government agency or a government actor as a party, right? This is Liberty versus Zinsky, or Zinsky versus Liberty right now, and he doesn't really think that the RIFRA argument applies. Now, Liberty fights back against this and said this puts us in a really awkward position where we have these arguments that this portion of Title VII as applied to us violates RIFRA, and you're saying, well, you can't raise that defense because there's no government actor as a party. And the court goes into some detail on this, but at the end of the day, it's that's not a clear cut issue. There are states that have actually done away with this. I think Utah recently passed a state RIFRA that actually does away with the government must be a party requirement and allows RIFRA defenses in private actions. So it's just an interesting thing to note here. In the interest of time, the only other one I'll mention in passing is there was a ministerial exemption defense here by Liberty, and it it was a little bit of a technical conversation. I'd be curious to hear, Mary Margaret, if you have any thoughts. But what the judge pointed out is at this stage, at the motion to dismiss stage, that it wasn't time for this because there's some case law that the ministerial exemption is a defense to a discrimination or an employment action. It's not a jurisdictional issue. So the judge said that there's case law to say that it's not appropriate to say, well, ministerial exemption, court can't weigh in, no discovery, this has to go at the motion to dismiss phase, that the ministerial exemption would come in later as a defense. I didn't look into this in too much detail. I know there is some case law on this, but it's kind of an awkward situation because if I understand it correctly, the ministerial exemption is kind of a branch off of the greater church autonomy doctrine under the First Amendment, which in some cases is a jurisdictional issue where the courts will say, we don't have jurisdiction to decide certain religious questions, and so we're out from the beginning. I guess the way the ministerial exemption has developed, it doesn't quite get applied the same way. But I'm curious before I go on, Mary Margaret, if you have any thoughts on this part.
Yeah, I really am looking forward to digging into this because it is a unique situation and honestly kind of confusing. I would think that yeah, I feel like I haven't seen this exact layout, this exact fact pattern before. So yeah, I'm as fascinated as you are here.
Yeah, I think this is a case that's probably worth some further work, and so I would expect we'll probably be working on some more in-depth resources, at least in-depth conversations on this case. It just came out. Like I said, it's dense. We just wanted to get to it for right as it was coming into the news here, because I think it will get bigger because it's going to quickly go beyond district court to the appellate courts, and this will be a newsy case, I think. But no, you make a great point about the RIFRA problem. Is that I think the idea is right? That this is about government burdens on religious exercise, just like the First Amendment is, right? That's the purpose of RIFRA, to protect against those. But you're right that it's not as if somebody is like banning speech in their private workplace and then someone is trying to rely on RIFRA. You're right. This is a statutory, it's a federal statute that's being relied on for the private action. So it's a little bit of a conundrum how RIFRA doesn't apply, even though at the end of the day, like you said, it is federal government action that is the cause of this lawsuit. It's just not the government being a party to the case. So I'd actually be interested to see. I think that this judge is standing on solid ground. I think the way he reads the statute is not unreasonable, but it does kind of create a problem for this class of case. So that was a great point. Now, I want to just go into a little bit of the Title VII exemption issues. I mentioned it in my intro to this case, but this is the perennial clash until we get, I think, another ruling from the Supreme Court. Probably is that I set it up a little before, but basically, anytime one of these issues happens, there's an argument over Section 702 and 703 in Title VII about the religious exemptions to the statute. So the important part, Section 702 in Title VII. So this subchapter shall not apply to a religious corporation, association, or society, or educational institution with respect to the employment of individuals of a particular religion, um, and so on. So this is always the argument: is that religious corporations or organizations are allowed to discriminate on the basis of religion under the Federal Civil Rights Act, under Title VII here, right? And that's intentional to make sure that religious organizations can hire and fire in accordance with their faith, right? It wouldn't make sense to have a religious organization that can't hire people of the same religion or people who subscribe to the same religious beliefs, or else there'd be no way to build a coherent religious culture, or really a coherent religious organization at all, right? So the this has been read more broadly, more narrowly, but I think the case law is pretty clear. There have been a couple of cases that point out that it doesn't just mean you can hire members of the same religion, right? It doesn't just mean Catholics are free to only hire baptized Catholics. It means that Catholic organizations can hire based on, where's the exact language? The based on the organization's religious tenets, right? It's definitely broader than just membership in the faith. So that's pretty clear. But then the counter argument from these SOGI, right, sexual orientation or gender identity discrimination lawsuits, is that, well, you're not discriminating on me on the basis of my against me on the basis of my religious beliefs. You're discriminating against me on the basis of sex, right? Which the door was open to that because of the Bostock case in 2020, right, where the Civil Rights Act on the basis of sex. Justice Gorsuch's opinion expands that definition of sex to include sexual orientation and gender identity. And then we more or less get to the place where we're in now, where we have these fights between religious organizations and people who identify as LGBT, or a different gender identity, whatever the case may be. So these are constant. And it's worth pointing out that Bostock knew that the Bostock case knew that this problem was being created and kind of punted it. And so I think now we're kind of reaping the rewards of it, right? The judge in this Liberty case says Bostock doesn't address the issue before us, but it provides a guiding light. And they go on to say that, where is it? Sorry, I have a lot of text highlighted on a lot of different pages of this opinion. Um, I will find it later, but basically the Bostock case said that oh, here it is. Uh, yes, there's going to be a problem when religious organizations have, religious reasons for employment decisions based on sexual orientation or gender identity. Justice Gorsuch was clear that the case that he was deciding was not a religious organization. So basically, they said, the way that these religious liberty protections interact with Title VII are questions for future cases. So they punted on this. Here we are, and it's a real problem. There are several other textual arguments. Again, if anyone's interested in Title VII and how it's going to develop on the religious liberty um, issue, I would strongly suggest you read this for yourself because I can't do it justice here. But in the Liberty District Court opinion, it begins on page 27. It goes for about 10 pages. And it really does a pretty good job of laying out the counter arguments of whether this is protected religious discrimination by liberty or impermissible sex discrimination. So before we wrap up this issue, Mary Margaret, do you have anything else you want to add on this one?
Well, I think we really will see this case probably go all the way to the Supreme Court. It's probably the strongest fact pattern, and it really gets down to the issue of you have faith-based university making an employment decision based on its religious beliefs, and then an employee saying, this wasn't really about religion. This was really about some other protected class. And I mean, it's a fairly clean case in the sense that the issue is right there, and the conflict is right there, and it is probably post Bostock one of the strongest fact patterns in terms of presenting that issue for Supreme Court consideration. So I'm looking forward to seeing the case continue. And as you said, Frank, it's on the one hand, the outcome is disappointing, but on the other hand, it's a well argued case addressing an issue that is of concern and probably does merit some judicial review. So even though personally, of course, I think that the motion to dismiss should have been granted, on the other hand, perhaps this will be a net positive in the sense that some clarity will be provided on what's at least a gray enough area that this is the cleanest, but maybe not the first case we've seen posing these questions.
Yeah, no, that's a great point. This is probably the test case to take the questions that Bostock never answered and admitted that it was not answering for religious organizations coming into conflict with the transgender protections. I do want to say one more thing on that note, and then we can move on. So for people who are observing and are actually going to read this opinion, at the bottom of page 27 of the opinion, the judge makes what I think is a pretty serious mistake, and really it echoes the mistake that I think was made in Bostock. So in defending Zinsky, the fired employee's argument on this sex discrimination versus religious discrimination, the judge says that Zinsky can argue that the ordinary meaning of the terms religious belief, practice, or observance, which are protected, at the time of the statute's enactment in 1964, religious belief, practice, or observance did not likely encompass an employee's sex or transgender status. Indeed, a separate term was used in the statute to capture ideas about an employee's sex, right, on the basis of sex. Now, I mean, I don't want to be disrespectful to a federal judge's opinion, but I think this is absurd. I mean, to say that, oh, well, in 1964, when this was passed, religious belief, practice, or observance would not have covered opposition to transgender ideology, right? If somebody comes in presenting as a gender different than their biological sex, that's not really a religious belief issue. But, well, if that's the case, it's because this didn't exist in 1964, right? And so but to say then to turn around and say that gender identity issues are captured by sex discrimination is, I think, equally untenable, because when they passed the 1964 Civil Rights Act, nobody was thinking that on the basis of sex meant transgender, right, status. That's just, if it didn't exist for purposes of religious belief, it also didn't exist for purposes of defining sex. So I think this is a very confused issue. Again, this is all downstream of Bostock, when we decided that the 1964 definition of sex would include sexual orientation or transgender identity, when that was not on the table at all at that time. Now we're in a very confused place and just trying to apply this statute to these kind of modern trends like transgender ideology. So I think as much as I've not said nearly enough on this case and or done it justice, I've probably said too much, and we should move on to the next case. So I'll turn it over to you.
Thanks so much, Frank. That was a great overview of a complicated but important case. And yeah, segues well into the next case that we'll cover today. This is O'Connell versus the United States Conference of Catholic Bishops. So many of our listeners might be familiar with Peter's Pence. It's an international collection that the Catholic Church uses to solicit donations, and these donations go to the Vatican, and the Pope has discretion over what these funds are used for. But the general spirit of them is they go to disaster relief, poverty, etc. And so a Catholic parishioner in Rhode Island um, was was in the audience in the congregation during the annual appeal for Peter's Pence, and he described himself as led to believe that the appeal was asking for funds that would be used immediately for charitable purposes. And he later came into possession of information that his donation was invested in a portfolio of investments, like still dedicated to charitable purposes, but he says that he was led to believe that the donation was going to be used right away and given to people experiencing poverty. So he brings this lawsuit claiming, I guess, like unlawful, or claiming like a violation of, it's actually a class action lawsuit claiming a violation of basically the terms of the exchange. And a friend of ours, Lyle Weinberger, wrote an outstanding piece for World News Group, looking at the issues here. So at this point, a lot of the litigation is centered around some technical questions about jurisdiction and other technicalities. But at the heart of the lawsuit is a really important question about, can the government, specifically the judiciary, jump in and kind of evaluate how a church is handling its internal affairs? And as you can imagine, under the First Amendment, this is at best highly suspect, but really government interference in this context is prohibited. So why is that? Well, there is this doctrine that Frank alluded to called the church autonomy doctrine, and it's derivative of, or really a rearticulation of, the free exercise and establishment clause. And Lyle's piece in World News Group breaks it down really well. He says the free exercise part is looking at the invasiveness of the government doing discovery, subpoenaing bishops, subpoenaing priests' emails, subpoenaing communications from the diocese, like all of the kind of intrusion that would be involved if the government permitted this litigation to move forward. Effectively, is a the government acting in this controlling way over a religious organization. And so that is a violation of the free exercise clause. And then the violation of the establishment clause arises because the government's going to have to take sides by allowing this litigation to proceed. It's putting the government in a position of dictating who's got the church's position right, the parishioner or the church itself. And so it puts the government basically in the position of dictating dogma. And so Lyle really clearly points out, and that the core with the church autonomy doctrine isn't even as much about outcomes in litigation, but really just about the fact that the litigation process itself requires a level of intrusiveness, invasion by the government, by the parties, and by the court overseeing all this, and that process itself is an establishment clause violation. And so I think this is a really interesting case that we'll see. And right now, where it is this there the USCCB is represented by attorneys from Beckett. The case started in district court and now is before the Court of Appeals. Again, on a couple different technical jurisdiction questions, but the core church autonomy questions are undoubtedly going to arise. So yeah, Frank, you and I have been talking a lot about church autonomy and learning more about this doctrine. And I should clarify too, it's called the church autonomy doctrine. It applies to all faith-based organizations, so synagogues, denominations that don't call their houses of worship churches, but it also applies to institutions that are not houses of worship. So this is a broadly applicable doctrine that's really important, and I would love to hear your thoughts on it.
Yeah, it's a tricky thing, right? And I think it makes people uncomfortable, like lay people, not judges so much, but to kind of grapple with the problems here. Because on one hand, I think it rightfully makes people nervous to say, well, you can't have recourse to a court if a church is mishandling or misusing money. And so the doctrine is developed in a way where, as this article that you cite points to, clear illegal misuse of money or deceit or fraud that is on the table, right? Like those things are not you. The churches, religions don't have autonomy to commit fraud, right, against the people who give them money. But the idea is that that line is pretty far down the road, right? That the court is not going to get in and quibble about, like you said, whether donations can be invested and then the interest can be used to get to for the poor, or like these are at this point you're meddling in, well, what is a donation? What can a church do with a donation? These are religious questions. And if anyone's interested in this issue, there's another case that's a little farther along right now. It was decided maybe a month ago in the Ninth Circuit. There was an en banc hearing. It's Huntsman versus Corporation of the President, which is a very similar fact pattern, actually. And so I won't go into too much detail, but just the long and short of it is that there was a Mormon or former Mormon, I think at that point, no longer a member, who had given millions of dollars in cash and stock over the years under the Mormon doctrine of tithing, right? So the Mormons as members had to tithe 10% of their income to the Mormon church. And there was this whole controversy where tithes were being invested, and then like the principal was never touched for business endeavors, but some of the interest made off of the tithing funds was being used for some development projects around the Mormon temple in Salt Lake City. And Huntsman sued and said, well, this is fraud, this is a misrepresentation. I was told that my tithes would never be used for business development, that these were separate funds. And um, the majority of the Ninth Circuit actually did decide that there was just no fraud, that Huntsman was wrong on the facts. But there's a really interesting concurrence in that case that I think would actually be helpful dealing with the Peters Pence case, where the concurring opinion says, well, there's a problem here in that to answer this question, we have to get into what is a tithe, right? Does the tithe include just the original money? Is the interest made off of a tithe part of the tithe, or is that a separate fund? And the concurrence, I think, rightly said this is church autonomy territory. We should not be weighing into what is a tithe, what is reasonable reliance for the purpose of whether or not a member should tithe, because they're all supposed to tithe, no matter what, right? The leader says a particular tithing fund is going to be used for. So I think it's just really interesting because you get this not well, this uncomfortable question of can courts ever weigh in when it looks like there's mismanagement of church money? And the answer is yes, but we do want to be really careful that in the process, courts are not answering questions about what is a tithe, what is a permissible use of church money, because as you said, this is First Amendment territory. These are not appropriate questions for courts to be answering because they're essentially religious questions.
The church autonomy doctrine almost reminds me a little bit of the business judgment rule in the private sector, where we're not talking about church leaders having civil or criminal immunity for illegal or criminal conduct, of course. But to the extent that there's discretion involved in the governance of an institution, um, the bar for government oversight, intervention, and intrusion needs to be it's high in the private sector under the business judgment rule. It should be even higher when the questions involve not only discretion and not only governance, but actually um, governance and interpretation of theological mandates and principles. So I'm really looking forward to seeing this case and the Huntsman case continue to develop. I think there was sort of a pause in church autonomy doctrinal development, and Lyle's done some great work on these issues, and I think it will lead to a more robust First Amendment jurisprudence overall that these cases are being explored.
Yeah, that's a great point. It's an interesting area. I think it is primed to be revisited and maybe advanced. I know there was a lot of focus on this with Our Lady of Guadalupe and the Hobby Lobby before that. But there are just one thing I'll point out. If anybody's interested in a deep dive onto the church autonomy doctrine, there's a really good long form essay at the Federalist Society review from maybe 3 or 4 years ago by Carl Esbeck. I think it's called, yeah, here it is, an extended essay on church autonomy. Very long. When I was new at Napa Legal, this was like a key resource to figure out all of these aspects of the church autonomy doctrine, but that's highly recommended. Um, all right, after some really heady stuff, we're gonna end with an interesting article, a little lighter. So, as Mary Margaret said at the beginning of this episode, there's been some articles being written about this. Mackenzie Scott, who is the ex-wife of Jeff Bezos, is that right? Yeah. So, has now billions and billions of dollars at her disposal over the last few years, has been giving very large unrestricted grants, sometimes several million dollars, to various nonprofits. I have a note here. It looks like she's given over $19 billion. Is that right? To over 2,400 nonprofits so far. Um, so what's fascinating about this is generally when donors give large gifts like this, they'll have specific guidelines for how and when a nonprofit can use them. Right? They'll be targeted toward particular programs or hiring particular staff members to do certain things or to start a new publication. Usually they're somewhat restricted to do something in particular the donor wants to see done in civil society, right? Um, Scott's donations have generally had no strings attached at all. So it's a pretty fascinating like sociology experiment to see what happens when you take like maybe a smallish nonprofit and just give them $5 million. And she's been doing this all over the country in a lot of different nonprofits. So it's been interesting because there have been some concerns by critics. There's a recent study um, that addressed some concerns, especially over for one, management of large gifts, right? What happens when you give a small nonprofit several million dollars? It's kind of like the personal equivalent of like when somebody who's poor wins the lottery, like how will they manage the money kind of thing. Um, But it's been interesting. They there was some pretty in-depth studies done, and it seems like most of these nonprofits did pretty well. I have here data from over wow, 800 nonprofit leaders' responses to a study here indicate that Scott's donations have helped the long-term health of the organizations that she gives to. 2 years after receiving a grant, most organizations that benefit from her generosity have had a higher investment growth rate than other nonprofits. The other big criticism is that the technique can make acquiring new donors more of a challenge, right? When all of a sudden you're flush with cash and you have this one huge donor who's giving you money, does it make it hard for to attract other donors? This same study said 70% of the nonprofit leaders uh, involved state that they've had no increased difficulty in their own fundraising. So I don't have a lot more to say about this, but I think it's a pretty fascinating thing that there's kind of this maybe old stigma that you shouldn't give large gifts to smaller nonprofits that without restrictions or guiding them how to use it. Kind of like I said, akin to the lottery thing. Don't give, somebody of low means $5 million with a lottery ticket because they're probably going to misspend it. But maybe that's not the case. It seems like a lot of these nonprofits have been transformed and really been able to accomplish their missions, and it hasn't, turned their fundraising and programming upside down. It's actually been really effective.
Yeah, I one of the statistics that I was very edified by in the study was that she really was giving to smaller organizations. The statistic that caught my eye was that her gifts were typically 77% of the recipient organization's prior year operating budget, which is very kind of outside the industry norm. Most large grants, most foundations actually do the opposite. They kind of, by as a matter of policy, will only give maybe 10% or less of an organization's operating budget. And she's kind of turning that on its head. And so it is, like you said, Frank, a rare opportunity to actually gather some data around whether this works. It's started out, it seems like, as an experiment, and the results seem really strong. And I noticed there were several other health metrics, financial health metrics around the organizations that were really encouraging. So it's these donations made a huge splash when they were announced, and it's encouraging to see that the net impact has been so positive.
So if there are any donors out there listening to this podcast who want to give large unrestricted gifts to places like Napa Legal Institute, they would be well used. And I think
So
with that we should
statistics support that.
I think with that we should probably wrap up.
Well, thank you very much for joining us for this episode of the Napa Legal Podcast. If you enjoy the content we are putting out, we would appreciate if you like the podcast and subscribe to our channel on YouTube, Spotify, or wherever you're listening. We hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues affecting religious liberty and the work of faith based nonprofits.
Talk to you next week. Thank you so much for joining us, and God bless you.